Hello everyone, welcome back to my English Law channel. So this video is going to be more about terms of a contract. So going a little further into it, and the subtopics that I'm going to examine are the following. I'm going to be looking at the different types of contract, whether it's B2B or B2C, terms both express and implied, breaches of those terms, the categorization of the terms that are breached, and lastly, defenses against breach, namely exclusion clauses. So remember that terms are broken down into three types. Is either a condition, a warranty, or an innominate term. An innominate term is confusingly sometimes called an intermediate term. And innominate terms were invented in a case called the Hong Kong fur back in the 60s. Remember, it's important to get the term in the right category because the remedies available for breach of the term vary according to what kind of a term it is. Because these contracts has terms and conditions. A condition is a term. All right. So if a condition is breached, then the innocent party is allowed to terminate the contract and seek damages, or could affirm the contract, which is saying, yes, I want to continue the contract, but still seek damages for the extent to which the breach occurred, the inconvenience, any loss that was caused, and so forth. Whereas if a warranty is breached, there is the right to seek damages, but there is no right to terminate the contract. The contract must carry on. Okay, so how do we tell apart conditions and warranties? Well, a condition is really at the heart of the contract, about the thing that you're being sold, the service being provided, something to do with the price, something really important. And that was as laid out in Poussard and Spires in 1876. Whereas a warranty is also from an 1876 case. The best explication of precisely what a warranty is will be found in Bettini and Guy, 1876. This is a famous case where an opera singer was due to perform, and there was going to be something like a month of rehearsals before his very long run of the opera. He arrived 4 days late for that rehearsal, and so the person who'd hired him, Spire, said, forget it, termination, you breached a condition. And the court said, no, that's not true, it's a warranty, because if you'd failed to show up to the first night, and there was a female opera singer who once did that, or was ill for the first few days, you could terminate for that. But he only missed the rehearsal, and only a few of the rehearsals, so it's quite possible to go ahead with the contract, and as he hasn't rehearsed quite as much as you were hoping for, and perhaps his performance wouldn't be as good as it ought to have been, you might be able to seek damages for that, but you can't terminate on the basis of something which is relatively unimportant. That was a warranty, not a condition, that he make it to all those rehearsals. So the judge was Blackburn in the Bettini case, and he said, whether a particular stipulation goes to the root of the matter, so the failure to perform it would render the performance of the rest of the contract by the plaintiff a thing different in substance from that what the defendant was stipulated for, or whether it merely partially affects it and may be compensated for in damages. That's the end of quotation. So a warranty partially affects the contract, and therefore the claimant can be compensated in damages. So going on to innominate terms, often called intermediate terms, is we have to decide, well, what are the repercussions of the breach of this innominate term? Does it mean that the innocent party has lost whatever he was going to gain from the contract totally or in very significant measure? So if yes, if the breach of the innominate term was so bad that the contract is ruined, all right, then you can treat it as though it were a breach of a condition and you could terminate the contract. If, however, breaching this innominate term doesn't lead to such terrible consequences that the contract can still be substantially performed, in that case, you have to treat the innominate term as though it were a warranty. You can only seek damages. You cannot rescind the contract for this. Okay, and that's as per Hong Kong Fur and Kawasaki Kisen Kaishi 1962, a shipping case. So statutes have also classified these terms as conditions, innominate terms, or warranties. The Sale of Goods Act in 1979 says that the implied terms are all conditions, unless Section 15.15a says otherwise. So look at the key sections laying out the conditions, the implied terms of a contract. Section 12, title, as in rightful ownership of the item being sold, or indeed Section 13, description. If you say it's whatever, 100 kilos of potatoes has got to be 100 kilos. It can't be 98, right? If it was very close to 100, if it was just a few grams under, that might be acceptable. If it was slightly over, you're much more likely to get away with that. If it's way too much over, then again, that might be a breach actually, because the person's got more than they want, more than they can store and carry and so forth. If you said it was 22 karat gold, it's actually 20 karat gold. That probably a breach of a condition. Remember, there is some tolerance, some very tolerance, unless it's a strict liability contract. Very minor variation in the description might be acceptable. Remember, Section 14 of the Sale of Goods Act says there's got to be satisfactory quality. It doesn't have to be perfect, it doesn't have to be brilliant, but it cannot be bad. It's got to be good enough. And remember, it's also got to be usable for the thing that the person bought it to do, or the service has got to actually do what you need the service to do. Again, not to a superb standard, but it's got to be at least mediocre. Section 14, an implied condition about sample. If I give you a sample of whatever it is, the bulk has got to match the sample. I can't give you a sample of something which seems to be superb when the bulk of it is far lower quality. So the Supply of Goods and Services Act 1982 doesn't put the terms into different classes. However, it's widely considered that Section 13 about reasonable care and skill is an Innominate term. If you're providing services, you must do so with an ordinary level of diligence. Okay, you can't be very slapdash about it in providing a service. Right, so going on to the Sale of Goods Act 1979, Section 15A, it tells us more about how these are classified by statute. Look at Arcos and Ronisson, 1933. So a party claimed breach of contract because a trifling term was breached. It was an implied term that the goods must match their description. Well, Section 13 of the Sale of Goods Act, was that really a trifling term? This is what Lord Justice Atkin had to say about it. A ton does not mean about a ton. A yard not about a yard. Still less when you descend to minute measurements. Does half an inch mean about half an inch? If the seller wants a margin, he must, in my experience, stipulate for it. All right, say, well, okay, a ton. If I give you 3 kilos over or 10 kilos under, you've got to accept that as being close enough to a ton. So Lord Justice Atkin saying there are some things are strict liability. Some measurements, very fine things like medical instruments, is got to be precise. If it's wrong, it's not going to work. It can do a lot of harm. Okay, so the situation was set right by the Sale of Goods Act, Section 15A. So if the breach is so minor that the rejection of goods would be unreasonable, that won't operate. Or indeed, if the breach, however, if there is a breach here, it's treated as a breach of a warranty, not of a condition. So the parties themselves could put the terms into different classes, saying it's a condition or a warranty or an Innominate term. So the courts will usually uphold what the parties have decided, as in Lombard North Central against Butterworth 1987. However, there are cases when they don't. For instance, Schuler and Wickman 1974. This is what Lord Reed had to say sitting on the case. The use of the word condition is an indication, even a strong indication, but it's by no means conclusive. That's the end of the quotation, talking about intention. So the court could overrule what the parties had themselves stipulated in the contract. So Lord Reed went on to say that the particular construction leads to a very unreasonable result must be a relevant consideration. The more unreasonable the result, the more unlikely it is the parties can have intended it. Close quotation. So construction here meaning construal, how the court interprets the contract, saying, well, the parties were wrong or they misunderstood or something. They don't know enough about as much about law and terminology as we do. All right. So going on, if you're facing an exam question about this kind of thing, you look at the term that has been breached and find out, is it a condition or warranty, as statute said that? If it is whatever a condition or warranty, then you go by what the statute says. If no, well, then you have to think a bit further. So did the parties in the contract say this term was a condition or warranty? If so, then probably the court will hold that. But there are cases when they don't, as per Schuler and Wickman. Anyway, if the parties themselves haven't called it either a term or a warranty or an Innominate term, then you have to consider whether this is a condition, because at the time they contracted, it would have been considered so important that the innocent party would have the right to rescind the contract. as in does it go to the root of the contract, as we usually say, as per Poussard and Spires. So then it's probably a condition. However, if it's not that vital, it might well be an innominate term. Remember the test as set out in Hong Kong for against Kawasaki. Consider what the repercussions of breaching this term are. What would it do to the innocent party? Would he miss out on all of, or indeed most of, the benefit of the contract? If if the breach is so bad that it means that the innocent party gets no benefit or little benefit from the contract, then that's probably, you have to treat it as though it were a condition. If breach of this term is not so terrible that the innocent party doesn't miss out on the contract completely or doesn't miss out on it substantially, if it's a relatively minor thing affecting, let's say, less than half the contract, in that case, you'd probably treat it as though it were a warranty. So remember, you have to pay close attention to the precise words that are used. There are a number of precedents to look at. These particularly pertain to shipping or the transportation of cargo. So the Mikhailos Angelos about a ship in 1971, expected readiness to load, ship sailing from Hong Kong, I think, to the United Kingdom, and it was meant to be ready by a certain date in July, but the ship wasn't ready, and the people who hired the ship, they said, well, this is a breach of a condition, although those people who actually wanted to use the ship to transport their goods, they didn't even have the goods either at that time because a railway had been blown up in Indochina. Or think about when you're supposed to perform. There's Bunge and Trade Acts 1981. Okay, so remember, we've got to find out whether this is a business-to-business contract or a business-to-consumer contract, because consumers are protected more by the law on the basis they don't know that much about the law, they're not that wealthy, they can't stand up for themselves, they're not used to negotiating individual contract terms, they usually sign a standard form contract on a take it or leave it basis. They don't have a real opportunity to negotiate the contract. So that's just a little bit more about terms in contracts. So please book online lessons with me in law. I do lots of other subjects like history, politics, religious studies, citizenship, French, and so forth. Toodaloo.